We're recording.
And good morning, everyone. Welcome to the Appellate Court. I'm Judge Bright. I'm sitting this morning with Judge Mull and Judge Clark on the matter of your Mansion Real Estate LLC versus RCN Capital Funding LLC. The AC docket number is 43922. This argument is being conducted over the Teams platform, so everyone is appearing by video conference. In addition, it's being streamed live over the branch's YouTube channel. I'm going to ask everyone to identify themselves. We'll start with the judges, then counsel for the appellant and counsel for the appellee, just to make sure we can all see and hear each other okay. And I'm Judge Bright.
Good morning, I'm Judge Mull.
Good morning, Judge Clark.
Good morning, Attorney Matthew Gunter for RCN Capital Funding.
Good morning, Attorney Raymond Hesh for the appellee.
All right, I can hear and see everyone okay. I assume that's true for everyone else. If at any time you are unable to hear anyone, please let us know. If you are unable to see anyone, please let us know. And if you get disconnected from the argument for whatever reason, please log on the link you were provided. We will suspend the argument until we are sure that everybody is present. I'm going to ask everyone to keep their microphones muted during the argument, except, of course, when you are talking, to cut down on background noise and any feedback. I would ask everyone to keep their cameras on at all times so that we can make sure everybody is present and appropriately engaged in the argument. The judges are going to raise our hands if we have any questions, and we would ask counsel to recognize us. Again, we're trying to avoid feedback and talking over each other and unnecessary background noises. If you don't recognize us, we'll just jump in like we would in the courtroom. I would remind everyone that although we're doing this remotely, this is a courtroom proceeding, and we would expect everybody to behave and conduct themselves as if they were in the courtroom here at 75 Elm Street in Hartford. Each side will have 20 minutes to argue. I will keep the time. We do not have our light system, so I will hold up a sign when you have 2 minutes left, when you have 1 minute left, and when your time is up. Both sides have 20 minutes. The appellant can reserve some time for rebuttal. I think with that, we are ready to proceed. Attorney Gunter, are you ready to go?
Yes, Your Honor.
All right. How much time would you like to reserve for rebuttal?
5 minutes, please, Your Honor.
Okay, you may proceed.
All right. Good morning, Your Honors, and may it please the court. This case involves three major topics, and that is subject matter jurisdiction, the mitigation of damages, and grossly disproportionate and excessive penalties in violation of the 14th and 8th Amendments to the U.S. Constitution. Firstly, as to aggrievement. Again, statute section 49-8C states that liability would attach to a defendant or any person aggrieved by the actions of the mortgagee. And it's very important to note that it is an aggrievement requirement. And both classical and statutory aggrievement require actual harm. Classical aggrievement, where the court would have to find the duties that were breached, so to speak, or statutory aggrievement, where the statute specifically lays out the harm that causes the aggrievement, but both require the actual harm, the damages that result, especially with respect to torts. Now, this court had previously, I believe it was 2006, in Belmare versus Wachovia, stated in that opinion that actual damages were required, but it is RCN's position that that statement was dicta, as it was not required for the outcome of that case. That case involved the determination of whether Section 49-8C was a tort for purposes of the statute of limitations. So the holding in that case was, yes, this is a tort action, and therefore the statute of limitations runs in accordance with that amount of time. But it had nothing to do with whether or not there was that the aggrievement was met. The aggrievement was not an issue in the case. It doesn't discuss whether harm had been or any damages had been alleged or proven in the trial. It was strictly speaking, it was limited to a determination of statute of limitations based on whether it was a tort action or a contract action or something like that. So again,
So when the suit was filed, which would have been in April, when the request for the release to have been filed had still not been met, was the plaintiff aggrieved when it filed suit?
No, Your Honor. There was no, the release of mortgage had not been filed at that point, but there has been no aggrievement because there were no damages. There was no actual harm. And that was a point that was stipulated to, a fact that was stipulated to prior to trial, was that there was no pecuniary harm, there was no loss, and that the plaintiff had suffered no damages. So it is because of that's where we are, or my statutory or classical aggrievement argument goes. So without the harm, without the damages, without any kind of zero, you put the number 0 on this thing when you're comparing it to other monetary damages. There was $0 in damages.
Is it your position that a seller, which is what this plaintiff was, can never be aggrieved, or when could a seller be aggrieved under your view of this statute?
Certainly, when they actually suffer some damage. If the buyer were to say, "Oh, you haven't recorded the release yet, I need you to go do that," and then the seller spends some money to get that done. Again, and it's relevant a little bit to the mitigation argument as well. 49-8A gives the sellers the opportunity, or mortgagors the opportunity, to, through an attorney, file an affidavit on the land records in order to they can release the lien themselves. And if that happened, they would have recording costs. They would have maybe attorney's fees going with that. So those would be actual costs, actual damages. And perhaps then, again, later on, related to the constitutional argument, that would get into, its comparison to actual damages. Yes, sir.
So you said that if the attorney had to file the affidavit under 49-8A, the filing of that affidavit would be actual damages, right?
Yes, sir. That's one example.
Okay, so when the attorney has to send a demand letter 2 years later and draft a demand letter saying, "Hey, we still don't have a release," and the client has to incur the cost of the attorney sending that subsequent demand letter, isn't that damages?
Your Honor, that could be if those were alleged or proven. But again, here there was a stipulation that there were no damages. It is my assumption that this is that the attorney Hesh took this on contingency, but I have no idea. But again, no facts were proven, and let alone, we stipulated that there were no damages. So this might be a unique case where we arrive at a 0. Yes, Your Honor. What
about a buyer? Can a buyer be an aggrieved party under this statute, and under what circumstances could a buyer be an aggrieved party?
Certainly, Your Honor. If the buyer could, if the existence of the mortgage on the land records could be under the common law, what's it called, a slander of title. But again, that would require a malice. So again, it would require different facts. So if RCN were to have recklessly left the mortgage on the land records, then that could be something like related to this. If we had
so the mere existence and clouding of the title by virtue of a party's failure to comply with the statute would be insufficient even for a buyer to be aggrieved, in your view, under this statute?
Yes, Your Honor. They'd have to take some affirmative action, and either in time or in effort or in money, to clear up that cloud, so to speak. And in this case, because we have no damages by a stipulation, we don't reach that. And later, the amount of damages, the amount of effort that was used to clear up that cloud and get the mortgage released then becomes relevant to the constitutional argument, where we're comparing egregiousness versus the amount of damages, the amount of punitives. But again, I think it's at least the amount of damages in this case are 0. So that's that we reached no aggrievement. And again, the trial court had previously ruled in a motion to dismiss that there was an interest that had been an interest that the plaintiff had that could cause them to be aggrieved. it's certainly possible, because at that stage of the trial, there was no stipulation as to damages. We were just, again, at a motion to dismiss hearing. So it was still open for the possibility that there could have been damages. But later on the trial, we discovered that there were no damages, and we stipulated to that in order to avoid that kind of a trial where we had to prove anything like that and having additional costs. So agreement is, I guess, the most important factor in all of this. Because of the lack of agreement, there is no subject matters jurisdiction, and the case should have been dismissed. And again, going back to that Bellemare case, Your Honor, because it showed that this statute was a tort, the duty of mitigation of damages also applies now to the plaintiff, a separate and distinct duty to mitigate. And there were two issues with this. First, the court denied that there was a duty to mitigate, the trial court did. And second, the trial court did not allow in evidence that I was trying to elicit from a live witness that would have been highly relevant to the issue of duty of mitigation of damages. So because the plaintiff would have been required to do what normally a reasonably prudent person. Yes, sir.
So let's take a case where there's actual damages of $100. Okay, so we get over your aggrievement issue. There's $100 of actual damages, but there's statutory damages because it goes on for 2 years of $5,000. Are you saying that in order to be entitled to statutory damages, you have a duty to mitigate by either sending another letter saying, could you please release this, or filing an affidavit under 49-8A?
Not necessarily to the full amount, Your Honor. I should say it's our position that right before the clock starts running, that there would be a phone call, an email, another letter.
Well, if the legislature had intended that, wouldn't they have put that in the statute?
Well, Your Honor, I think it's the other way around. The common law duty is read into the statute unless the legislature specifically abrogates it and takes it out and says that it is not required.
Okay.
Yes,
All right, Attorney Gunter, let me ask, I want to make sure my understanding of the facts is correct. So upon the mortgage being paid off, there was an accompanying letter of some fashion, indicating that the payment is being made and citing to 49-8 and the lender's obligation to file a release, correct?
Yes, Your Honor.
So that occurred in 2015. And then I guess in early 2018, the plaintiff's lawyer sent another demand of sorts requesting that a release be recorded, right?
In addition to the payment of the $5,000, Your Honor, yes.
And so your view is that yet a third demand was required in order for the plaintiff to mitigate its damages?
No, Your Honor, it's that the letter would have been sent 30 days, 60 days around the time that the clock would start running for the accrual of the statutory damages. So the fact
okay, so when the mortgage was paid off, is it your view that your client had a statutory obligation to record a release?
Yes, Your Honor.
And yet 2.5 years later, the plaintiff still was obligated under a duty to mitigate to do what?
Well, Your Honor, it's our position that it would have been within that first 60 days. They're given you're given 60 days to get this recording, and then after 60 days, the clock begins to run $200 a week. So it would have been somewhere between the first letter of when the payment was made and the 60 days before the recording had occurred. Somewhere within that 60-day period. Reminder, I haven't seen the release yet. It hasn't been recorded yet. What's going on? This is a normal occurrence. This is what attorneys all around the state and all across the country do. I mean, this happens from time to time. A release does not get recorded by accident.
So help me understand your argument that the court should have allowed this evidence that these requests are being made all the time or with some frequency to RCN Capital. How does that help you? Doesn't that simply suggest that RCN Capital is not complying with its statutory obligation to get a release recorded?
Your Honor, I think it speaks to the fact that it is, while unfortunate, it is a normal occurrence throughout the entire lending industry that sometimes these fall through the cracks. And it is normal, and is what a reasonable person, again, mostly attorneys and title companies do, is that they call or email or a reminder, hey, by the way, I didn't get that release. Can you do it? It's, oh, yes, of course. I don't know what happened to it. It must have fallen through the cracks. I'll do that right now. It takes 5 minutes. That's just the normal course of action.
All right,
So-
I want to follow up on one thing that you said in your brief with regard to this second claim. So on page 14 of your brief, in the first full paragraph, you make the representation, or the argument, I should say, that the trial court also erred by not crediting, and you refer to it as the evidence of plaintiff appellee's counsel's statements in open court that, you know, he had this conversation during a recess with, you know, someone he knows named Ray. And so my question is it your understanding that representations of counsel can constitute evidence?
Yes, Your Honor.
All right, I would encourage you to follow up on that, because that is just not correct. If they're not under oath, it's just not evidence.
Thank you, Your Honor. Seeing my time is running short, I wanted to address our last point briefly as to the constitutionality of this case, or of the statute. And again, this is an as-applied challenge, so it's relevant only to the facts of this case, in that the amount of the penalty is not really relevant. It is the ratio of the penalty versus the compensatory damages. Again, here there are no compensatory damages. We have 0 versus $5,000 plus attorney's fees, which I'm not bringing up at this point because I really don't know exactly how much they are at any given point. But even just the $5,000, we have a 5,000 to 0 ratio. I've been unable to find any case of such a high ratio. They're normally in the single-digit multipliers or double-digit multipliers, 10, 12, 15. There have been a couple in the 100 times the amount, but nothing in the thousands. It is, again, for those reasons that it would violate the excessive fines clause of the 8th Amendment.
Your time is up. You'll have 5 minutes for rebuttal. Attorney Hesh, are you ready to proceed? You're on mute.
I'm okay now, Your Honor?
Yes.
Thank you. Your Honors, let me say at the outset, I'm not a litigator. I practiced real estate law for some 60 years now with my daughter and my son. So this is a little bit out of my purview. However, I can tell you this, that the issue with unreleased mortgages is a chronic, serious, ongoing, title clouding, plaintiff stressing, economic impacting problem. There's nothing I hate more than having to call up an elderly couple and tell them, look, Mr. Smith, we have a problem with your sale. There's an old mortgage of record that hasn't been released. And the response is only, well, how could that be? I paid that mortgage off years ago. Well, I believe you, but it's still of record. And we try to chase down the lawyer who handled it. He's retired or dead, and on and on and on and on. Judges, it's a big problem. If I don't have 8 to 10 release of mortgage issues on my plate every day, I don't have one. Anyway, getting down to agreement. The case law has long held that actual damages need not be proven. I'm citing Belmare, Smith versus GMAC, Mortgage Corporation, And the fact that this is manifestly a civil penalty has been the consensus of courts around the country construing statutes analogous to 49HC. And as far as the duty to mitigate damages, this is an obligation imposed on the defendant. It's his duty to mitigate damages, and he could have mitigated damages by settling this claim years ago instead of carrying on year after year with all of these arguments, some of which I think are superficial and silly, but I think the defendant has itself to blame as far as mitigating damages is concerned. And I would mention, for the record, whether it's relevant or not, I don't know. But we never once, since this issue started, got an offer of settlement. Nothing. That tells me that this defendant is pretty haughty, and I don't understand what their thinking is, but it certainly isn't any approach to handle a settlement. As far as constitutionality is concerned, the trial court ruled that the issue was made by way of defendant's motion for summary judgment, and this motion was thoroughly briefed and argued by both parties before Judge Radcliffe, who denied the defendant's motion on April 8, 2019. The recovery prescribed by 49HC is not excessive. Defendant's argument is preposterous that the damages award stemming from its own enduring refusal to pay the mandated statutory penalties is punitive and violation of its right to due process. And Bridgeport Harbor Place versus Ganem held only when an award of punitive damages can be fairly categorized as grossly excessive in relation to the statute's legitimate interest in punishment and deterrence does it enter the zone of arbitrariness that would violate due process. Finally, I would say again that as far as agreement is concerned, anytime a lawyer issues a policy, anytime a lawyer signs a letter of indemnification guaranteeing to release a mortgage, that lawyer is grieved, is a plaintiff as well, as long as that mortgage is outstanding of record. And also, not to mention the fact that it does slander the plaintiff's financial character by showing that record is outstanding. And I think that's all I have to say at this point, Your Honors.
All right, I don't see any questions from the panel, so thank you for the argument. We'll hear from the LE in rebuttal for 5 minutes, or appellant in rebuttal for 5 minutes. Hey, Gunter.
Thank you, Your Honor. I guess going to the last argument first is, Attorney Hesh, referenced letters of indemnity, or there could have been, the warranty on the warranty deed, slanders of title, again, without malice. These are all possibilities for damages. These are all possibilities that could have occurred because of a letter of indemnity or a warranty to the buyer. Those are all circumstances in which damages certainly could have occurred, but they didn't. This is maybe a very unique situation. I think it's a little bit more common than Attorney Hesh is letting on for having no damages. But even if this is a one-off case, there are no damages here. Without damages, there is no aggrievement. I think it's just really the end of it with that. Again, as to mitigation, Attorney Hesh is certainly right in respect that RCN could have fixed the problem itself. That's true of really any tortfeasor. They could have fixed the situation by not committing the tort. But it is a separate and independent duty to mitigate those damages. It is, and you know, it's really not that much effort that we're asking to have been done. It's a phone call. It is an email. It is another letter. It is something that is routinely and normally done. Again, it doesn't happen 20 times a day. I mean, for us, it's maybe once in a month we might get a letter that says, "Oh, it's been more than 30 days." I say, "Oh, you're right. You know, it's that one got lost in the mail or something." It's, you know, it happens. It's a circumstance that just happens occasionally, and we fix it. It's something that we are constantly reminded of. You know, with attorneys or borrowers or title companies, they just ask for it, and we give it to them, and that's all we're asking for. Is that is a normal and reasonable, prudent person would do, which is the standard to apply for this. And again, lastly, to the constitutionality, it is those Gore guideposts from BMW versus Gore, the U.S. Supreme Court case from 1989. It's focusing on reprehensibility. Again, there is nothing reprehensible about RCN's conduct, nor does the statute in its legislative history point to any reprehensibility, and rather it's about remedying an inconvenience. The second guidepost, looking at the relationship between the punitive damages to the compensatory damages, again, 5,000 to 0. So that is it is a very broad difference. It is it's a grossly excessive difference. We're not talking. Yes, sir.
So let me ask you, if it was 0 and the suit was brought after 2 weeks, so it's $200 per week. So if it was $400 and the damages were still 0, would it be excessive?
Maybe on a technical basis, Your Honor, but I think that would be something that the court would be able to, again, looking at the different histories of different cases, I think, the 200 to 0 multiplier would be probably okay, constitutionally speaking.
So I'm not going to go every increment with you, but if the way the statute is set up, you have about a minute and a half left. The way the statute is set up, it seems to be incremental in nature to try to get the conduct that the legislature wanted. Isn't that an appropriate use of a civil penalty like this to incentivize conduct by making it incremental in terms of its impact?
Yes, Your Honor. I don't think I have the case in front of me, but there was a similar case, an excessive fines case, where there was parking fines. The amount was small. Parking fines accrue daily, as far as I'm aware, in this case. I think it was in Los Angeles. But even though they accrued daily, the fact that they accrued so much versus the harm that was being caused, the parking on a city street, that was held to be unconstitutionally excessive. And I believe I briefed it, and if the court wishes to have any supplemental briefing, I certainly could. But it's not, the incremental nature of it doesn't really have much to do with this analysis. I don't believe it's rather that the total that had accumulates. And again, it's not really not about the total. It's this gigantic ratio. It's this harm that is well out of proportion.
Yeah, the problem, of course, is that the total got larger because you guys didn't respond sooner. So you kind of created a constitutional issue by letting it accumulate to a larger and larger amount.
Yeah, I see my time is up. May I briefly answer your question, or
sure? Go ahead. Yeah, go ahead.
For practical matters, if a mortgage release has been lost in the shuffle for 1 day, it's going to be lost in the shuffle for 1,000 days. It'll never be brought up again if it gets lost in the shuffle unless somebody asks for it. So the fact that it is now gone past the 60-day mark, or past the amount of time that accumulates $5,000, that's really beside the point. It was one action that caused the tort, or one action that caused the penalty.
Yeah, but what we have to decide is whether the legislature intended to encourage mortgage companies to put in systems to prevent those mortgages from getting lost. and whether that is a reasonable use of its civil penalty powers. All right, I want to thank counsel for participating in the argument in the virtual courtroom today. We will take the matter under advisement. We will stand in recess until 2 o'clock this afternoon. Thank you both. Have a good day.
Thank you, Your Honor.